A fun fact is that the Constitution of the United States doesn't actually say all that much about the Supreme Court. I have my copy here in my hand, so I'll read you. Here it is again. I'll read you what the Constitution says about the Supreme Court. There's not that much. Article 3. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at the stated times, receive for their services a compensation which shall not be diminished during their continuance in office. I'll read a bit of Section 2 as well. The first chunk just states that the judicial power shall extend to all cases in law and equity arising under this Constitution, and then kind of describes it a bit more. Then we have, in all cases affecting ambassadors, other public ministers, and consuls, and those in which the state shall be party, the Supreme Court shall have original jurisdiction, which just means that's where the case begins. That's where you go to achieve relief initially. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. That just says that everything else that might come to the Supreme Court happens under its appellate jurisdiction. It's a court of appeal, the last court of appeal. And Congress has the right to structure that however it may go. And then Section 3 of Article 3 is about treason. But not much about the Supreme Court, just kind of a few sentences. Pretty much everything about the Supreme Court, other than the fact that it exists, is structured by statute, by Congress. The fact that the Supreme Court has 9 members, that is an act of Congress. The fact that the Supreme Court sits in a building, that is an act of Congress. The fact that the Supreme Court can choose its caseload, that is the result of an act of Congress. Everything but the existence of the court itself and its powers are the results of an act of Congress. And even its powers are shaped by acts of Congress. I bring this up because I've argued on the page and in video that there needs to be Supreme Court expansion. That if Democrats in particular hope to have any hope at realizing their agenda, having an agenda that can survive judicial scrutiny, that they need to add more justices to the Supreme Court, because the current Supreme Court, which has been a Republican supermajority Supreme Court since the addition of Amy Coney Barrett in 2020, which has had a Republican-appointed majority since the 1970s, the current Supreme Court is hostile to progressive legislation. It's hostile to ordinary liberal legislation. It's simply hostile to use of the government to solve social problems. It's hostile to visions of federal power that are much more robust than what conservatives and MAGA reactionaries are comfortable with. It's hostile to the idea that the Constitution protects a full suite of rights and that people have the ability to realize and actualize those rights in courts of law. We can look at the past decade and see how the Roberts Court has virtually destroyed the Voting Rights Act, has nicked away at rights to bodily autonomy, has made partisan gerrymandering much more of a serious problem, has destroyed campaign finance law and allowed money to flood into our political system. If you want any of this to change, you gotta have a more liberal Supreme Court. And the only pathway to that doesn't involve waiting for 50 years is appointing new justices. So I'm bringing up the reality of what the Constitution says about the Supreme Court to emphasize something very simple. You just have to pass a law to expand the court. It is quite possibly the easiest thing to do when it comes to reforming the court. In previous times when I've made videos about this subject, people have said, well, why don't we just impeach justices? Why don't we just get rid of the court altogether? Why can't we get rid of judicial review? And there are reasons for that, some quite practical. An impeachment trial requires a 2/3 majority in the Senate, and there's not going to be a 2/3 majority for impeaching a Supreme Court justice. Why don't we abolish the Supreme Court? Well, that would take a constitutional amendment, and so unless you can get supermajorities of Congress as well as a supermajority of the states to agree on this, I don't think it's going to happen anytime soon. And why can't we just get rid of judicial review? Well, that's a slightly more complicated thing, but the fact of the matter is that judicial review was present in American jurisprudence before the Constitution. It's very much an emergent property of any kind of constitutional system. If you have a written document that is sort of the highest law of the land, and you have a final court of appeal, that Court of Appeal is going to inevitably evaluate laws based off of whether it corresponds to the highest law of the land. You're going to get judicial review. It's just that's the elements in play produce judicial review. And there's a lot of evidence that the framers expected judicial review to emerge. Judicial review can be weak or strong. We have a pretty strong form of it, and there are probably ways you can curb that. But it's gonna exist. Now, the way to move forward in court reform is simple. It's just changing the size. And the size of the court has changed. I'm doing a Trump thing here. The size of the court has changed over time. The first Supreme Court had 6 members. In 1807, the court grows to 7 members. In 1837, it grows to 9 members. It grows to 10 members in 1863 when Republicans in Congress need a court to rule with Lincoln. And then it shrinks to its current size in 1869, 9 members. FDR, of course, tried to expand the court, and that didn't work out. But there's nothing about the principle that the court can be expanded through congressional action that's wrong. And in fact, there's a practical reason for it. For a long time, the number of justices corresponded to the number of circuit courts of appeal. Right now, there are 13 circuit courts of appeal. So by the historical rule, you might say, if the number of justices equal the number of circuits, you should have 13 justices. One justice handles every circuit. And in fact, back in the 19th century, justices used to ride circuit, that they would actually be part of the circuit courts themselves. The circuit court, in fact, would just comprise of a justice and a district court judge. Now there are firmly established circuits, but each justice is still responsible for a number of them. But you can just have one justice per circuit. And after that, it is the case that the United States needs more judges. Since the last major expansion of the judiciary in 1979, we have 100 million more people in this country. We have so much more legal work that needs to be done. We actually need more judges. We need more district courts. We need more circuit courts. And so why not create a couple more circuits, 15 circuits, 15 justices. You add 6 more justices. There you go. You've expanded the court. And there's a perfectly reasonable reason to do it as well. I will end this by saying that there are other things you can do if you feel that the court is running roughshod over the rest of the political system that involve Congress's ability to regulate the court under that clause relating to its appellate jurisdiction. In the past, Congresses have considered things like imposing a supermajority requirement on the court for overturning pieces of legislation. And there's other things you can do as well. I mentioned earlier that the building the Supreme Court sits in isn't mandated by the Constitution. It's something Congress gave them, and Congress can take it away. Congress can tell the court, you can't sit in this building anymore. You have to meet in the basement of Congress like they used to. Congress can take away funding from the court. Congress can take away the court's clerks, can take away their air conditioning. The power of the purse is very powerful, and Congress can do a lot with it. It wasn't until the early 20th century that the court had full control over its docket, could choose which cases to take, and you could take that away as well. You could say you have to take whatever cases come your way. You can't pick and choose anymore. Lots of things Congress can do using its power to structure the court's appellate jurisdiction to discipline the court. But ultimately, if what you want is a Supreme Court that's going to be more amenable to liberal or progressive legislation, or just to liberal and progressive governance, then you have one option. You got to expand the court. And I think that the task for those people who are hoping to have a more progressive national government, one of the tasks is to convince the party that's nominally going to be responsible for that, the Democratic Party, that they have no choice but to support court expansion, that it has to be a non-negotiable for future support from Democratic politicians. Do you support expanding the court? And part of that is, do you support ending the filibuster? No filibuster, court expansion. That's where it has to be. That's where it has to go. There's not really any other choice if you hope to govern in a progressive manner. End the filibuster, expand the court. There is no alternative. There is no other choice. If you want to govern in a progressive manner, these are the things you have to do.